So, legal scholarship, like all academic disciplines, is subject to the postulation that value commitments ought not to influence our professional work. For many existing and future lawyers, however, the values underlying their daily work is directional to their career choice. For these reasons, I would like today to look with you at why and how effective altruism could be endorsed by or implemented in legal scholarship. I would first like to look at the question why legal scholarship should be even guided by normative principles in the first place. This might be a very conservative question to you, but it's actually a very debated point in law. Second, on the assumption that this hypothesis is assumed, the question is what normative claims should be endorsed by legal scholarship. And then I will argue on this basis that effective altruism, in short EA, is especially apt to be endorsed by law. Third, the principal task of a lawyer is to find out how these ethical claims can be transported or translated in law. How this is to be done, however, is obscure to many. Now, the traditional view has been that law is isolated from other disciplines, such as sociology, economics, politics, or ethics. Especially embedding ethics in law, it is argued, contravenes postulates of scientific objectivity. Scientific objectivity expresses the idea that claims, methods, and results of science are not or should not be influenced by particular perspectives, value commitments, community biases, or personal interests. Objectivity is thus equated with an absence of normative commitments and with ideals free of moral, political, and social values. The idea that objective legal scholarship in this limited sense exists and that it ought to be endorsed by legal scholarship is defended by legal positivism. Legal positivism demands that we solely interpret law and describe it. The approach is based on the argument that law and politics, notably, ought to be strictly separated, which is famously defended by Hans Kelsen. Increasingly, however, the positivist approach is criticized and condemned by legal scholars on multiple grounds. First, legal positivist endeavor is not objective. The process of interpreting law is inherently tied to overarching theories that these legal principles ought to follow. Already the choice of subjects and objects of the law, the act of verbalizing, clarifying, and ordering law, means that scholars apply their own presupposed framework onto a seemingly objective analysis. Thus, legal positivism flies in the face of the logical inseparability of values and science. Second, there is never an absence of normativism. One cannot not have an ethic, right? So normative goals permeate scholars' contributions and even entire fields of law. Think about human rights law, which has the goal of furthering humanity. Or think about environmental law, which protects sustainability and which is guided to preserve ecosystems. Or think about trade law, which reduces trade barriers to the detriment of social values. Already procedural laws express normative values by laying down which actors ought to possess claim rights, how transparent legal processes ought to be, and how much deference judges ought to possess. It is illusionary, therefore, to think that law and normative values can be clinically separated. Third, pure positivist analysis even hosts adverse effects. So, as legal judgments carry with them political implications, turning a blind eye on the objective existence of these powerful claims of law engenders a false security, as Anne Peters points out. Proponents of critical positivism, which stands in contrast to legal positivism, therefore, argue that there is a middle ground between unrealistic postulate of value freedom and limitless evaluation. The content and consequences of this approach is that lawyers ought not merely interpret the law, but they ought to contribute to changing the law. Endorsing critical positivism means justifying and criticizing law as well as making reform proposals. Now, to meet considerations about potential overreach to politics or ethics, a number of security valves or caveats are employed. First, critical positivists owe duties of transparency to readers, so they must make explicit which part of their analysis concern law itself and what is called from law in terms of ethical claims. Second, reality checks are employed to show that, or by switching back and forth between general theories and legal practice. Additionally, law is complemented by empirical studies which show how law is formed and what effects of law there are, and by ethical approaches to the law. Thus, in the overarching framework of critical positivism, legal scholars suggest ideas and advanced solutions without harboring too many illusions, however. Thereby it contributes to realistic as opposed to illusionary utopia. Critical positivism is predominantly typical for young and undeveloped fields of law, such as international law. Now, since animal law is an even younger and an even less developed field of law, this dicta applies all the more to animal law. Having argued that law must be responsive to ethical claims, in a second step, it is incumbent to map and assess what normative or ethical claims shall be endorsed by legal scholarship. Now, this question is usually one outsourced by lawyers to ethicists, right? So as a lawyer, I might slightly overstrain my scientific qualifications, yet as I have had recourse to several specialists in that field, I hope that this will suffice for the purposes of this talk. Now, to many lawyers, the term ethics itself has numerous meanings. In a questionnaire done by Raymond Baumhart several years ago, businessmen were asked to tell them what they think what ethics is. Among the answers were, ethics has to do with what my feelings tell me is right or wrong. Being ethical is what the law requires. Ethics consists of the standards of behavior our society accepts. I don't know what the word means. So, although the content or the grasp of ethics is hard to grasp itself, it is now understood as a branch of philosophy comprehending values and norms which guide our actions. Now, among the many existing ethical theories, a strong divide is usually employed between deontology and utilitarianism. Deontological ethics, which advocates for actions' adherence to rules, has certain trumps. For instance, the establishing absolute prohibitions to infringe certain legally protected rights, such as the prohibition of torture, encourage long-term positive social behavior. Utilitarianism, on the other hand, advocates for moral actions which maximize utility, for instance, the well-being of sentient beings. Effective altruism has a vexed relationship to those two theories. Now, EA, as you all know, is a philosophy that aims to determine the most effective ways to improve the world. Many effective altruists strive to combine the elements of the utilitarian goal of reducing suffering with the deontological rules-based actions as a sustainable way to reaching the objective. Sustainable in this sense means that the manner in which the most effective reduction of suffering is sought supports positive change of action as soon as this is possible, yet not in a manner which endangers reaching the objective in the first place. Altruism's effective nature requires that EA is practical and so-called livable. So if altruism overstrains our capabilities, it is likely that we are not effective and we do away with the concept in the long run. Now, the utilitarian element in EA ensures that we reconsider policies so as to have the most individuals benefit therefrom. It necessitates that we think more globally and more rationally about ways to improve individual situation, mainly via cause prioritization. EA, by combining these two elements, is posited as a synthesis of cooperative compromise between ethical theories, and it is for that reason that it is especially apt to be translated into law. In this sense, I would like to continue my talk by focusing on high-priority EA topics. High priority means that there is a large quantity of suffering for a high number of individuals, while conversely requiring little action to change the status quo. Although one could also focus on other high relevance EA topics, I will focus herein on the regulation of non-human animals, in short, animals. I would therefore like to address ways in which lawyers can translate and incorporate EA considerations via critical positivism. From a broad perspective, there exist various ways of doing so. Beginning with the most obvious, but also most difficult point, that is career choice. Career choices highly influence lawyers' capabilities of implementing EA considerations. Clearly, critical points can more easily be made in a job that gives employees the discretion to do so. So if I work as a legal academic or as an expert in animal law, I have much more flexibility to profess new helpful concepts for animals. Whereas when I work as an attorney or as a court clerk, the margin of flexibility is arguably negligible. Now, since law has become such a large field of law that touches on various political, economic, and ethical realities, lawyers face the need to specialize in certain fields. By taking such a choice, lawyers can steer the degree to which they can implement EA considerations in their work. For instance, fields of law having no impact on animals are very apt for earning-to-give careers. On the other hand, fields of law which have an impact on animals' well-being, whether that be directly animal law or environmental law, trade law, etc., gives attorneys more room to helping animals most effectively. Closely related to this point is the consideration of how much a job gives someone discretion to influence others, whether that is other lawyers or the public. Additionally, interweaving work with EA considerations entails thinking about one's focus of research. EA-based law is designed to help animals most in need, animals whose capabilities to sentience and cognitive grasp about their suffering is established, and third, animals who have been largely invisible to the law. Applying EA considerations to law therefore requires that focal point is laid on farm animals. This can be done either directly by focusing on farm animal law or indirectly by focusing on other fields of law which help to establish farm animal welfare or farm animal rights in the long term. For each of the possibilities, I would like to give you two examples I have been working on. So on the one hand, farm animal welfare can be given more prominence in a direct manner. In my article 3R for farm animals, I propose an extension of the 3R principles in research to the field of farming. First, I expounded ways in which research animal welfare differs from farm animal welfare. From a global perspective, research is among the most regulated fields of law. The 3R principle in animal research firstly entails refining legal approaches to animals. In other words, refinement aims to decrease the incidence and severity of infringements upon interests of animals, both physically and psychologically. Secondly, the principle of reduction prompts scientists to use the smallest number of animals while attaining scientific objectives, which is mainly done through the design and analysis of experiments. Third, the principle of reduction prompts scientists to replace animals wherever feasible alternatives exist, ranging from studies on patients, cellular screening, computer models, lab-grown organs, and many more. Now, the 3R principles has been accepted by a large majority of states and by numerous highly respected international organizations. The 3R have been perceptibly contributing to better welfare. Since the 1970s, the global number of animals used for research has been cut into half. Farm animals, on the other hand, have been shown to be subject to the most intensive animal interest infringements. Quite shocking in contrast thereto is the lack of their regulation. So on the international level, farm animals are not regulated. On the national level, however, farm practices are usually exempted from the law, or they provide ridiculously low levels of farm animal welfare regulation, or they do not address the topic at all. Farm animals are therefore, from a legal point of view, essentially discriminated in contrast to research animals. The minimization of pain, the decrease of severity, intensity, and their substitutability is never checked. This finding is all the more astounding as research animals account for 1% of all animals killed each year for food. Thus, farming affects 98% of all domesticated animals in the world. In a second step, it was incumbent to identify the substantive arguments which led to a higher introduction of protection for research animals. Russell and Birch, authors to the famous 1959 publication called Principles of Humane Experimentation Technique, which played a key role in the introduction of 3R to research, perceived the stress encountered by animals in research as a humanitarian problem. Other documents, such as the European Convention on the Protection of Animals in Experimentation, show that the rationale is based on the consideration that animals are capable of suffering and that we owe moral duties towards animals. In a third step, it was shown that the rationales which led to higher protection of research animals are in fact shared by farmed animals. A high number of animal welfare laws, constitutions, even regional documents express and recognize that animals are sentient beings capable of suffering, including farm animals. On this basis, therefore, the 3R principles ought to be extended to farming, meaning that we ought to refine the conditions that farm animals are in, that we ought to reduce their numbers, and that we ought to replace their use wherever feasible alternatives exist. In consideration of the aim of research to save lives and the aim of farming to create culinary pleasure, the application of 3R to farming is even more exigent. It is quite clear that the 3R principles are subject to high levels of abuse, potentially. For instance, if the necessity of research projects or the necessity of an intensity of a project is conducted by biased persons, 3R is of a low utility. However, this is a deficiency of how law is applied and enforced. But it does not change the fact that 3R have the potential to reduce animal welfare suffering in the short run and eradicate the use of animals in the long run, if strictly applied and enforced. On the other hand, legal work can also benefit from animals indirectly. In this context, I would like to draw your attention to the Great Ape Project, in short, GAP. The GAP is an international project that aspires to prompt national legislators to introduce rights for animals, namely for great apes. Currently, what separates humans from animals with regard to the extent to which their interests are respected and protected are the legal tools they are given. Whereas humans are holders of valuable and effective tools called rights, animal protection is currently reduced to the margin where their interests are not overridden by human interests. Rights are proposed to be established for great apes simply because they are cognitively among the most developed animals, because they share a high degree of genetic material with humans, because they can suffer profoundly since they are aware about them suffering, and because they resemble humans and vice versa, humans relate to them. In very simple words, great ape rights are established for those animals for which rights establishment is most likely. Speciesism, which currently shields animals from possessing rights, must be replaced by qualitative criteria to ensure great ape rights. So you might say on its face, well, the GAP is very low in terms of EA impact, yet once rights are established for great apes, rights can benefit other animals, for example, farm animals, and they will likely be accorded rights and therefore better protection. The introduction of rights for additional animals can then not be refuted simply on the grounds that they are not human. By establishing rights for animals, they will possess so-called trump cards that operate as limits or vetoes to encroachments, conferring them a theoretical advantage. Thereby, the automatic practice of trumping of human over animals' interest will be replaced by a qualitative analysis of the substantive interests at hand. In a recent contribution, I tried to find the best and most effective way to implement the gap consideration in the Swiss legal framework. For these purposes, I first presented the gap, showing what it is about, the international efforts, and addressing the most compelling objections to it. To break down the rather theoretical nature of the project and to make it more practical or tangible, I elucidated the special features of the Swiss legal framework with regard to great apes. So, for instance, the Swiss Animal Welfare Acts protect great apes only, quote, as far as circumstances of the intended purpose permit, unquote, and thereby fails to live up to the clear sentiocentric position of the Swiss animal welfare or the Swiss legislator. Through reports of the Swiss expert committees on animal experimentation and non-human biotechnology expressed that balancing interest in the context of great ape experimentation is impermissible. The Swiss Supreme Court itself ruled that animals which suffer to a higher degree should be given higher protection. Finally, the constitutional provision of the dignity of the animal lays down that animals possess an inherent value and that they should not be means to others' ends. In a second step, it was imperative to examine how the gap could be implemented in the Swiss laws. This point notably dealt with the level of implementation. In principles, the great ape rights could be implemented on the international, the federal, or the cantonal level. It was concluded that provision should be placed aside to the dignity provision of Article 120 of the Swiss Constitution, evidencing that animals' dignity is the basis of their rights. Having animal rights established constitutionally ensures that there is a universal application and that they can only be limited on the basis of recognized principles, such as the rule of law, public interest, proportionality, and by respecting the core values of rights. Implementing great ape rights in the Animal Welfare Act, on the other hand, undermines the purpose of great ape rights and effective protection of their interests, because such rights could easily be ignored for constitutional guarantees, such as economic freedom, the guarantee of ownership, or freedom of research. Finally, it is conceivable that substates, or cantons for that matter, further great ape rights in their own sovereign constitutions. Cantons continue to be pioneers in the introduction of new rights, but also in furthering or further developing existing rights, thinking about the right to apartment or the right to work. Establishing state constitutional great ape rights requires that there is no conflict with federal law. Based on either of the two possibilities, great ape rights or the gap itself can be moved from claims of utopic thinking to realistic realities of responsible interaction with sentient and highly conscious animals. And in the long run, farm animals can profit from these efforts which incrementally change the legal conscience in our interactions with animals. To conclude, I would like to draw your attention again to the fact that legal scholarship ought to be guided by normative principles. Doing so allows states to rely on EA as a guiding principle, which is a synthesis of the most accepted and compelling ethical theories that should be translated to legal scholarship via critical positivism. Lawyers should find ways to apply and implement EA's normative claims by career choice, specialization in research, and by formulating concrete legal proposals. In doing so, they should consider addressing the following questions. What are the current biases in law with regard to sentient beings? What is the problem with the status quo? Why is there a need for change? Can legal proposals be made that go beyond merely criticizing existing law? Which stakeholders are affected thereby? What are the practical consequences of reform proposals? With this list of questions, I would like to conclude today's talk, and thank you very much for your kind attention. Looking forward to it.